What's up, guys? It's Ron from Ronald Rohde Law, and today we're going to talk about the Corporate Transparency Act. All right, this is really critical for real estate investors. If you create or if you own an LLC, you're going to need to know what is required of this new federal legislation that affects everybody. Ron from Ronald Rohde Law, and if you follow this channel, thanks for tuning in. I'm super excited. As a brief detour, today my daughter's drawing is, that's me. If you can see those big bloodshot eyes, I think she got some influence from Ren and Stimpy. If anybody knows that cartoon, that's what I think of. Back to the topic, the Corporate Transparency Act. This was passed a few years ago, and essentially the federal legislation passed by Congress is to collect a systematic database of the owners or the beneficial owners of state-maintained entities, corporations, LLCs, not trusts. The Corporate Transparency Act was signed into law on January 1st, 2021. It has taken 3 years for the federal government to announce and actually create an enforcement date for compliance with this law. It is going to require all beneficial owners or substantial control of entities to report to the federal government. What is a beneficial owner? This includes individuals who own 25% or more of the entity's equity interests or have significant managerial control. And now it is finally going to take effect January 1st of 2024. So just roughly, I'm going to go into a little bit of detail about what the law requires. You're going to have to disclose the owner. You're going to have to create an account with FinCEN, that is the U.S. Department of Treasury's Financial Crimes Enforcement Network. And it's basically their anti-money laundering, anti-terrorist arm of the government. And what they want to do is be able to cross-check different ownership and see if it comes across any law enforcement issues. For real estate investors, it's really important because this is their one way of tracking a very valuable asset that does not flow through the monetary system, through the banking system, which is real estate. They are very keen on tracking ownership and trying to determine if anybody that is on their watch list owns real estate. And so if this is a partner that you're involved with, if you're in a joint venture with them, or maybe they haven't updated the information, you are at a real risk of non-compliance. Now, with fines running $500 per day per violation, not just a violation of the act per person, but per violation individually, you could be looking at the maximum statutory penalty of 2 years in jail or a fine of $10,000. Now, the requirements are that after you form a new entity with the state, you have 30 days to submit this beneficial ownership. Some of the requirements that you have to provide: full legal name of the owner, the date of birth, the current residential or business address, as well as a unique identifying number from government ID. So this can be a passport, a driver's license, but this is the amount of information that you have to provide. And the duty to provide that is on who is registering the company, who is the applicant. So in a lot of cases, that's going to fall on us, your lawyer. You want to make sure that your law firm has the information and has an account and is prepared to file that within 30 days of formation or within 90 days of knowledge of a change. So you can assign interest, you can transfer to somebody else, but then you have 90 days to notify FinCEN of a change. Who is going to use this information? So they've already said that they are going to share it with other federal agencies. I think probably that's going to go to IRS. It is going to go to the FBI, different federal agencies. They have said that it will be available for local law enforcement through subpoena, but it's not going to be a public database. You cannot send a FOIA request, and state agencies or even civil lawsuits between private parties, right? Let's say I just sue somebody else, are not necessarily going to be able to subpoena this database and access this information. However, I think, from our perspective as a company that forms hundreds, dozens of LLCs every week, every month, this is going to increase compliance costs. And at the end of the day, the bad actors, they're going to be able to skirt the regulations. They're going to have a straw man no matter what. And all it's doing is going to increase the burden on regular people who have to file now additional bureaucratic compliance. So we are going to be raising our costs, but you should be aware of this because there are extreme civil and criminal penalties for this. And I think your lawyer or your CPA, whoever files that, could be held responsible if they don't submit that information. Ultimately, it's the beneficial owner. They're responsible for submitting it. We call that a BOI registry. Are there any exceptions to this rule? There are a few exceptions, but they primarily deal with publicly traded companies, large companies with 200 employees, $5 million in sales, accounting firms, different real estate investment trusts. And those are exceptions because they are already reporting that information to the SEC, the Securities and Exchange Commission, or maybe the FTC. They're regulated by another federal agency, so they're already providing beneficial owner information to another agency. There is one exception for inactive entities. So if you have an entity that existed prior to January 1st, 2020, if it's not engaged in business and it's not owned by a foreign person, if it has not experienced any change in ownership, has not sent an amount greater than $1,000, and does not hold any other assets, then this type of entity can be exempt. I think that people are going to be trying to use the other exceptions for real estate, but to be honest, they're not going to apply. And so my advice is to file as many LLCs as you want prior to the end of year, 12/31/2023, because entities that were filed prior to January 1st of 2024, you have a full year to report that beneficial owner. The 30-day rule only applies if you file it in 2024. Any entities that were filed prior to January 1st, 2024 will have a full year to comply with the reporting obligations. So that's it for this video on the Corporate Transparency Act. It has been a long time coming. I've talked a little bit about it, but feel free to drop any comments if you guys have questions about compliance.